Hey everyone, Angela Langlotz here, trademark and business law attorney, and I'm back and I'm answering more people's questions. I'm going to go ahead and tag Angela Williams Stillwell because I am answering her question. I want her to know about it. I am answering. So, what Angela wanted to know, good name by the way, say hi to me if you're on. I see I have two visitors. Go ahead and say hey, let me know. If you have any questions, go ahead and put them in the comments and I will answer them in a future live. But what Angela wanted to know was, what's automatically copyrighted content versus what needs to be trademarked brand? Okay, so this is, I always try to kind of translate for myself what people are really asking, because sometimes people don't always know how to express their question. I think what Angela's asking is, what's the difference between a copyright and a trademark? And what rights do you get without registration? So I will address the first issue and then I will address the second issue. So the difference between a copyright and a trademark. And if you're here, say hi. Hi, Mark. Thanks for showing up. So here's the difference between a copyright and a trademark. A copyright is to protect creative works reduced to a tangible medium. What does that mean? A tangible medium is anything you can see, hear, touch, taste, smell, perceive with your five senses, right? What are some examples? Some examples might be a poem. It might be a play. It might be a book. It might be an arrangement of lights on the Eiffel Tower. No kidding, no joke. That is actually copyrighted because the arrangement of the lights is creative. So you can take a photograph of the Eiffel Tower during the day, but if you take one at night, you're actually violating the copyright of the company that installed the lights on the Eiffel Tower. I'm not even kidding about that. What else? A work of choreography, a dance, a song, a musical composition, anything that can be, has to be creative, right? So it can't be useful. It has to be creative, primarily creative, to be covered by copyright. What is a trademark? A trademark, in contrast, exists to protect the distinctive source identifier that is attached to certain goods or services. And a trademark can be anything. Yesterday, we discovered that trademarks can be colors, right? And I talked about how the distinctive green color of the Big Green Egg barbecues / smokers is actually covered by trademark, right? They actually, Big Green Egg Inc. actually has trademark protection for the color green for barbecues. Strange, but true. Hey, Tony, glad you made it. Hey, Fred. So anything that distinguishes your goods and services from another company's goods and services can serve as a trademark. Notice that I said that it has to be distinctive. In other words, if it's generic or merely descriptive, it's not going to be able to serve as a trademark except under very limited circumstances, which I won't go into now, but may go into at a later date if people send me questions about that. Okay, so that's the difference between a copyright and a trademark. What rights do you have if you don't register? Okay, let's start with trademarks. I'm sorry, let's start with copyrights first. At the moment you reduce your idea, your creative idea, to a tangible medium, it is covered by copyright. And anybody who copies that work is liable to you for copyright infringement. And this is so even if you don't register your copyright with the United States Copyright Office. So why register at all? Well, because the registration gives you rights to certain damages and gives you less to prove at trial, right? It is presumed, for example, that if you register with the Copyright Office, that you're the creator of the work and that you created it on a certain date. So you don't have to prove those things. They are presumed. So, and you're also eligible for statutory damages, which means that you don't have to prove actual damages when you go to sue somebody for copyright infringement. You are able just to get, excuse me, it's Texas and we all have allergies here, forgive me. This is how I roll. These are not polished, it's just me. So you don't have to prove damages. If you register your copyright, you're able to get statutory damages for copyright infringement. What do you have if you don't register your trademark? If you don't, hey Marianne, I'm so glad that these are valuable to you. That's why I do them, and I have a lot of fun doing these too. And I do have my mug OT this morning, and it's full, so that's good. For those of you who haven't been introduced to the mug, that's fine. Go back and watch my previous videos. What do you get if you don't register a trademark? If you don't register your trademark, you do still have common law trademark rights, but those rights are limited to the geographic area where you've actually used the mark, okay? And if you don't register, you don't get the benefit of a lot of presumptions that you do get when you register your trademark. You don't get the presumption that you're the first user. You have to prove that. You don't get the presumption that you used it on a certain date. You don't get the presumption that you're the actual owner of the mark. So you have to go prove all these things at trial. Anytime you have to prove things, just think about standing on the front porch and lighting $100 bills on fire, because that's what you're going to be doing at court. You're going to be paying an attorney at their billing rate, which is generally north of about $500 an hour. We don't come cheap. We copyright and trademark attorneys because we're specialists. So you're going to be paying an attorney to prove all of these things at trial. You also don't get to sue in federal court for trademark infringement. You're going to be stuck suing in state court every place your trademark is being infringed. That's really expensive. Getting a federal trademark registration is a lot cheaper, okay? So Marianne, I see you have a question, and I can answer that. I don't really quite understand your question, but I'll answer that on a future live if you want to expound upon it a little bit. Anyway, what else don't you get? You know, when you don't register your trademark, the other thing that you don't get is you don't get to be found in the trademark registry at the United States Patent and Trademark Office, which means that the trademark examiner may issue a registration for a confusingly similar mark to yours because they don't know that you're using it, because they don't go out into the rest of the world and look to see if anyone else in internet land or in anywhere else land is actually using the mark in commerce. They look at the trademark registry and that is it. And if your registration can't be found, then the trademark examiner may issue a registration, a trademark registration for a mark that is confusingly similar to yours, and then you have to go oppose the trademark registration, or if it's already been issued, try to get it canceled. That's a very expensive process and is much more expensive than just registering your mark in the first place. So I think it's kind of stupid that people don't register their marks, but I understand that I think it's going to be really expensive. It's actually not. If you have questions about that, you know, get on the phone with me. I'll talk to you about it for 15 minutes for free. And you can schedule a consultation with me at TrademarkDoctor.net/contact. There is actually a link where you can schedule a time to talk with me for 15 minutes at no charge. You should take me up on that. Anyway, so that's the difference. And if anyone has any further questions, just comment. Go like my TrademarkDoctor.net Facebook page and you will be notified every time I go live. So you won't miss an exciting episode of, what do I call this? Trademark Talk, I guess I call it. And I will see you tomorrow. I will be here again tomorrow, same place, not exactly the same time, but around the same time. And with that, I will see you all tomorrow. Ciao.